Stop for a moment, because this could matter more than most Veterans Affairs headlines you see online. If you served between 1970 and 1999, you might be leaving $2,800 on the table every single month. Not because Ottawa suddenly created a magical new check for every veteran, and not because there is some automatic deposit coming to everyone who wore the uniform, but because the 2026 VAC rate update has made older monthly entitlements easier to measure, and in some cases easier to recognize when they were underclaimed, underrated, or never fully linked to service in the first place. If your file is old, incomplete, or sitting on the wrong decision path, the difference between what you are getting and what you should have been assessed for can be serious. And if you are one of the people who assumed, if VAC owed me something, they would already know, this video may be the wake-up call you needed. Here is the real problem, and it hits older veterans harder than many people realize. The pre-2000 record gap is not a conspiracy, but it is a genuine barrier. A lot of service-related injuries from that era lived in paper files, unit notes, handwritten medical entries, CF-98 reports, witness recollections, and duty details that were never packaged in the clean digital trail younger applicants now expect. VAC says that for all claims, service health records are reviewed to confirm the link between your service and your claimed condition, and only records received directly from the Department of National Defence or Library and Archives Canada are used for decision-making. That means if your old file is thin, scattered, or missing the one page that ties the condition to duty, the problem is not always your diagnosis. The problem is the link. That is why so many older veterans feel as if the system can see their pain but still cannot see their entitlement. Now here is the pattern interrupt, because this is where many good people lose years of money. The old assumption was, I served, they have my file, they know what happened, so eventually the right payment will show up. That is not how this works. VAC itself says one of the most common reasons disability applications are denied or assessed lower than expected is a lack of sufficient evidence in the original application. In plain language, if the file did not clearly connect the injury, illness, or worsening condition to your service, the system often did not fix that on its own. A human being has to see the new evidence. A reviewer has to reopen the logic. What many veterans casually call a manual review is usually a very specific process inside VAC, and there is one exact phrase and one exact form that can completely change the way the conversation goes when you call. I am going to give you both in the middle of this script, because if you remember only one thing from today, it should be that phrase. Let us break down where the $2,800 a month headline actually comes from, because trust matters more than drama. The number most closely matches the 2026 Disability Pension Class 5 monthly rate for a single pensioner, which is $2,810.78. That is an official rate, effective from January 1, 2026. But that does not mean every veteran who served before 2000 is entitled to that exact amount. It means that a missed or underassessed monthly Pension Act entitlement can live right in that range. On the other hand, if you are under pain and suffering compensation, the maximum monthly amount listed for 2026 is $1,419.82, while additional pain and suffering compensation can reach $1,851.93 a month for Grade 1. For Pension Act clients, attendance allowance can go as high as $2,324.88, and exceptional incapacity allowance can reach $1,859.93. So the money is real, the monthly rates are real, and the gap can be large, but the route to that money depends on which benefit structure your case falls under. This is where older service history becomes critical. VAC states that for most Canadian Armed Forces service, a disability pension applies only if the application for disability benefits was made before April 1, 2006. Otherwise, many veterans are dealing with pain and suffering compensation under the newer framework. That distinction matters, because some viewers hear $2,800 a month and immediately think everybody from the 1970s, 1980s, or 1990s is owed the same missing benefit. That is not correct. What is correct is that veterans from that period are more likely to have legacy paperwork, older adjudications, historic service records, and claims pathways that deserve a fresh look. Also, if you received a Pension Act benefit or certain related benefits between 2003 and 2010, VAC says you may be eligible for a disability pension corrective payment because of a calculation discrepancy from those years. Most of those payments are automatic, but not every situation is automatic, especially if you no longer receive a benefit or you represent an estate. So what should you actually do in 2026 if you think your file was missed, underrated, or built on an incomplete record? Start with My VAC account. VAC says the portal allows you to apply for benefits and services, communicate by secure messaging, track the status of your applications, view a summary of your benefits, and update your personal information. That matters because older veterans often try to solve a records issue entirely by telephone, when the better strategy is to create a visible paper trail inside the portal as well. If you are starting a first application or reopening the evidence trail around a condition, use the guided web form in My VAC account. VAC says it saves automatically, targets questions to your condition, can fill in some information for you, and helps ensure required areas are completed. That is important if you are tired, frustrated, or dealing with a condition that makes long paperwork harder than it used to be. Next, slow down and build the service link properly. VAC says the first disability benefits application is Form PEN 923, and the most important part for many veterans is the section where you explain how the condition relates to service. This is where older files often fail. Do not write one vague sentence saying your back, knees, hearing, shoulder, or mental health issue came from service and leave it at that. VAC specifically points applicants toward details such as when and where the event happened, whether you sought medical attention, whether there was a CF-98 or witness statement, whether you were on leave or on duty, and whether you were serving in a special duty area or special duty operation. If the condition came from repeated exposures or repeated tasks rather than one dramatic incident, say that clearly and chronologically. If it was one injury made worse by years of duty, say that. If it was one service-related condition that caused another, say that too. A proper timeline is not decoration. For many pre-2000 files, it is the bridge between, I know this happened, and VAC can legally recognize it. Now, here is the part a lot of people misunderstand. VAC says it will obtain your service health records directly from the Department of National Defense or Library and Archives Canada, and only records received directly from those bodies are used for decision-making. In other words, you can and should request your own copy so that you can read it, check it, and identify gaps or key dates, but you cannot fix the adjudication simply by mailing VAC your personal photocopies and hoping for the best. What you can do is use your copy to build a stronger statement, point to missing periods, highlight likely treatment windows, and make it easier for VAC to find the right part of the official record. Add supporting civilian medical reports if your current diagnosis or present level of impairment is better documented outside the old military chart. If you are released from service, VAC says relevant medical questionnaires may be sent to your current doctor or health professional. In My VAC account, also make sure your proof of identity and any needed supporting forms are complete, because missing basics still slow real cases. Let me give you the one mistake that sinks more claims than almost anything else, because this is where the fear of missing out becomes real. The biggest reason older claims are rejected, delayed, or underrated is not usually that the veteran has no health problem. It is that the application never cleanly linked the diagnosed condition to service with enough evidence. VAC says one of the most common reasons applications are not approved, or are approved at a lower assessment than expected, is lack of sufficient evidence in the original application. That means incomplete service record links, vague applicant statements, no witness material when one existed, no explanation of whether you were on duty, and no medical bridge showing the condition remained chronic or permanent. If you served in peacetime, VAC says coverage follows the compensation principle, which focuses on illness or injury that occurred while on duty. If you served in wartime or certain special duty situations, the insurance principle provides broader 24-hour coverage. If you do not explain where your case fits, you leave the adjudicator to guess, and guessing is not a benefit strategy. There is another point most people miss when they talk about a 2026 update. The update is not just that rates are higher. It is that the higher rates make old underassessments more visible, and that matters when deciding whether to seek a reassessment or a review. VAC says if the disability for which you are already receiving benefits has worsened, and medical evidence can show the change, you can request a reassessment, and the first step should be to call VAC or visit a local VAC office. So if your condition is already accepted but the severity is out of date, a reassessment may be the right road. If the issue is that evidence was missing from the first decision, a review route may be better. And if you were part of the 2003 to 2010 Pension Act calculation discrepancy and you no longer receive VAC benefits, or you represent the estate of a deceased recipient, VAC specifically says to contact them. That is not a rumor, and it is not clickbait. It is an official notice that still matters. Alright, here is the reveal I promised. The phrase you need to know is, departmental review. Those two words matter because VAC says that if you have new evidence that was not included in your original disability benefits application, you may request a departmental review. And the critical form number is PEN 6205AP, officially titled the Departmental Review Application. This is the formal route many people mean when they say they need a manual review. It tells VAC that the file should not just be left where it is. It should be examined again in light of additional material. If you do not agree with a decision, or if the assessment came in lower than it should have, this is one of the most important tools available before you move on to the Veterans Review and Appeal Board. And if you want help, the Bureau of Pensions Advocates can assist with written submissions and forms, free of charge. So when you call VAC, do not drift into a vague conversation about whether somebody can take another look. Be precise and respectful. Say, I am requesting a departmental review of my disability benefits decision, and I want to ensure new evidence is added to the file. If you are working on a first claim, ask about PEN 923, the disability benefits first application. If you are dealing with a worsening accepted condition, ask whether your facts point toward reassessment. If you are an older Pension Act client or reviewing old records from a 1970 to 1999 service period, ask whether your current entitlement, assessment level, and any related monthly allowances have all been properly considered under the record available. If VAC says the original application lacked detail, do not take that as an insult. Take it as a roadmap. Build the timeline. Tighten the evidence. If the departmental review still does not resolve the matter, VAC explains that the next stage may be the Veterans Review and Appeal Board, with review and appeal routes beyond the departmental level. And let me leave you with this, because service should be met with honesty, not noise. The right message is not that every veteran who served before 2000 is automatically owed a secret $2,800 check. The right message is that some veterans from that era may have legacy entitlements, underassessed monthly benefits, outdated severity ratings, or unresolved evidence gaps that can absolutely translate into very real monthly money in 2026. The official rate tables prove that the numbers are significant. The official review rules prove that missing evidence can be corrected. And the official application guidance proves that the service link is where many files live or die. If this sounds like your situation, do not wait for the system to remember you perfectly. Put your years of service in the comments, because that helps other veterans find this information and realize they are not alone. And if you know someone who served in the 1970s, 1980s, or 1990s and still says, I never bothered because the paperwork was too messy, send this to them. With respect, with gratitude, and with full honor for your service, thank you for what you carried for this country.